I call to order the October 24, 2023 Special Magistrate proceeding for the rental program. My name is Robert Riggio. I'm the Special Magistrate who will be hearing the matters today. Do we have any announcements?
No, sir.
None. Okay. And I have approved the September 26, 2023 meeting minutes and provided them to our recording secretary and our clerk. And right now would be probably an appropriate time to have all of those city staff members who will be giving testimony this morning to come forward to be sworn, so we don't forget to do that.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
All right. Today we have 2 lien reviews. We have 5 irreparable, irreversible rental cases and 1 item of miscellaneous business. What I would like to do is to take the item of miscellaneous business, which is at the end of the agenda, and move it to the front of the agenda and get that out of the way. And I see the attorney for the party in this matter, Florida Pacific Leasing Company, is present. So let's get started, and we're going to move item 6 to the beginning.
Okay. Could you state your name, please, sir?
I'm Michael Moore here on behalf of Florida Pacific Leasing Company.
Thank you.
Yes, ma'am.
Okay.
And good morning, Mr. Riggio, Anthony Jackson, attorney for the city on the beach.
Okay, this is matter styled SMG 01-2270, Florida Pacific Leasing Company, LLC, who had been cited to correct violations of Article 6, Section 6.1 at 316 Main Street. Probably, Mr. Jackson?
Yes.
Will you lead off and tell us where we are on this matter?
Yes. Mr. Riggio, as you know, this is docketed for your opportunity to be responsive to a court order that came out of the appellate court to make findings of fact and to modify an order that had been previously entered into this case, SMG 01-2270, Florida Pacific Leasing. As part of that, the deadline for responding would be November 3rd. We have docketed for us to be able to come before you today so that if you wanted to handle it, you could, but we have an alternative solution. And I say we, meaning I've met or spoke with and communicated through electronic means as well with Mr. Moore, who is counsel for the respondent. And we've come up with what we believe is a reasonable and fair solution to this. As you may recall, this is a case that came out of 2022, or I guess the beginning of the year, and ultimately was resolved. I think the findings ultimately were findings that were compliance, non-compliance, but at that time it was for a different reason. It was because it wasn't happening anymore because it was during a special event. But ultimately, everything that was of concern regarding the licensings that we felt that were needed and so forth have been taken care of. The real effect of these violations with businesses that are affected by the master plan is that it affects participation. That's been resolved, and the business has been allowed to participate. And so the reality is that we found jointly that there was no benefit for going back to the appeals court for this additional finding and doing additional briefing from both parties and waiting for a ruling that really has, in many ways, would be moot. So what our request is as the city, is to ask that the magistrate would vacate the order. And the reason we're willing to vacate the order is because there were actually two orders, two different cases, and they both had the exact same effect. They were both compliance, non-compliance, and ultimately resulted in these the master plan effects. That so the vacating of this order doesn't really change what actually happened ultimately, but it would prevent this additional necessity for more cost and more functions that we believe are not really beneficial to either party at this point. So our request is to just vacate our prior finding of noncompliance, and my understanding from Mr. Moore, our agreement, and I know what he said was to be recommending. So I don't know if his client has already spoke to the issue, if he's got resolved that, but our anticipation is that they would be seeking to dismiss the appellate case as well, so that there wouldn't be any additional action necessary from you in the appeal. Of course, alternatively, if it's not dismissed, we'd probably just file a motion to dismiss on it being moved.
Mr. Moore?
Yeah, I don't disagree with a lot of what Tony said. I mean, if the city moves to vacate the SMG 012270 case and the order entered in that case, then it would moot the appeal. There's nothing really to appeal at that point.
Yes, correct.
I was kind of surprised to see that you were appealing something where you had been found ultimately to be, as the order stated, that there was non-compliance, but then you were in compliance.
It's the interpretation of the ordinance.
The
Legal interpretation is the conclusion of law that was drawn.
The impact is that as a member of the master plan, as a participant in the master plan, that our land development code, as it is right now, would suspend their right to participate for 3 years. So that's the effect of what any business, not just them. And so that was worked out, though, with through the levels of authority that could work that out.
Okay. It's my sort of recollection that when Mr. Morris spoke, it was sort of their lack of participation in the master plan that got them into this situation. The master plan, in fact, allowed for certain waivers and variances that were not available to entities that didn't participate. And so it would seem kind of ironic to kind of try to keep them outside of it, which would probably mean they'd have to end up reappearing here again. And it would seem that what you're saying sort of works to the city's advantage as well as to Main Street Station's advantage, if I'm correct in that.
Well, ultimately, the most important part is that, as Mr. Moore had indicated even then, they had been working on getting the city's concerns resolved, and ultimately they were resolved with what we felt were licensing requirements and so forth. And so everything's good. It's been good for a period of time, and so that's where we are today.
All right. So
Something happened this weekend, which I don't know about. I don't assume anything happened this weekend.
Sorry.
I said unless something happened this weekend, which I wouldn't know about, but I assume nothing happened.
I have not been made aware of anything.
Okay, I think we're fine.
Okay.
We've been good, and I think we are good.
all right. So I'm amenable to that. I had worked up a statement of facts, but it's a very complicated affair. But since it involves alcohol service, it's an issue that does have some ramifications, because I know, the alcohol licensing tends to oftentimes go off in arcane areas, and if we don't need to go there, we don't need to go there. So therefore, I'm willing to vacate the order.
And of course, the respondent, Florida Pacific Leasing, has no objection to that.
Okay, well then, let's see, what was this originally case style?
This was
SMG 012270.
yes, sir.
Okay, so therefore, in case SMG 012270, property at 36 Main Street. I am hereby,
I'm sorry, 316, I think you said 36.
316 Main Street.
Yeah, okay.
I hereby vacate the order which was entered on February 23, 2022. And what else would you like me to add to that? If there's
I think
anything?
if you vacate it, Your Honor, I mean, there's nothing else for
Yeah, I
us to
think
do.
it's done.
Okay,
God bless.
if that solves your problem,
Yeah, and for the benefit of the magistrate, if there's an actual dismissal, I don't know, voluntary dismissal, if y'all can do that prior to the
Yeah,
third, that would
could we-
benefit.
I would do that. What do you want me to do? Serve you guys?
Well, I just want to make sure that I don't want to leave the magistrate into being in
Uninformed?
contempt of the
Uninformed?
appellate order.
Yeah, and
So-
so I could do that, or I mean, I can send him a copy of the notice of dismissal. And will you enter a formal order, a short formal order, memorializing the vacation? Miss, I
Yeah,
see Miss
we'll send
Barnes
you-
Yes,
shaking
Yeah,
her
we'll
head.
send you a
we'll be
copy.
quick on it.
Okay, it
Soon
doesn't
as-
have to be very long, but okay.
Absolutely.
All right,
Okay.
and after you do that, I'll file a notice of dismissal and copy you and the magistrate and Miss Barnes, and we'll be good.
Sounds great.
Okay.
yeah,
God
so,
bless.
you know, if I end something and say that you're in compliance, keeping this going on just to have your client end up continuing a matter in circuit court doesn't seem to be productive for anybody.
I'm sorry, I didn't understand.
Your client would still be in circuit court, even though I had found you in compliance in the original order, and it doesn't seem to have any productive value at this point, so.
You underestimate the importance of the legal conclusion that you drew. I think, I don't want to go back and relitigate the matter, but I think we're good.
Yes.
But that is acceptable to the city?
Absolutely. Yeah, the biggest thing is everything that Mr. Moore said at the end is what we need, and I'm sure he'll follow through, and good working with you, Mr. Moore.
Well, God bless. Thank you and Madam Clerk for allowing us to go first and get out of here. I
Okay.
hope you guys have a great day.
Okay.
God bless.
All right, thank you, man.
All right, we'll go back to we have today the rest of the agenda, and we have lien reviews. Are they present?
Yes.
Okay, so we will start with lien review number 1, 521 Division Street, RTL 06-2027, Samuel L. and Rhonda P. Ferguson. Is there anyone here on behalf of the Fergusons?
We met, Denzel Sykes, the code compliance
Have you-
manager, met with her, and Carl was present.
Okay.
And there was an agreement at the
Fine.
meeting. Carl can speak to that.
Yeah.
Okay.
Carl Wexenberg, City of Daytona Beach.
I just want to make sure that if they're not here, that you at least, have spoken with them, and if you've reached an agreement.
Yes, sir.
And if you could continue with your presentation as to your introduction and
Yes,
your name.
we actually met with Mr. Ferguson on the 18th at our office around 1 in the afternoon. There was a discussion that ensued, and after the discussion, it was determined that we were going to reduce the lien to $5,000, and Mr. Ferguson had agreed to that. And he understands the process of 30 days. It could go back.
Okay. That's acceptable to me. Therefore, in case number RTL 06-2027, Samuel L. and Rhonda P. Ferguson for property at 521 Division Street, I hereby order the lien in that case to be reduced to the amount of $5,000. Subject to being paid within 30 days, of the fine will revert back to the original amount. And should the respondent in this matter be listening in, I always have the caveat, if there is a problem with paying the money, then they need to contact the city attorney or the city staff immediately to let you know. and perhaps some arrangement can be worked out. But other than that, they have 30 days to pay it.
Okay, thank you, sir.
All right, lien review number 2, 836 Berkshire Road, RTL 052199, Willetta Harmon. The current owner is Rose Investments LLC, and there is currently a lien on the property in the amount of $16,213.44.
Good morning. I'm Inspector Luana Domingo with City of Daytona Beach Code Compliance. My credentials are on file with the city. We did, oh, she's on Zoom. Okay. I thought she would be here.
Yes. Can you hear me on Zoom?
Yes, I can hear you.
Could you state your name, please?
Myra Panora?
And raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Sorry, Luanda. Oh, she is the current owner. She is of Rose Investments.
Yes.
Yes.
Ma'am, could you tell us what your relationship is to Rose Investments?
I'm the owner for Rose Investment. Same thing with my sister. She's here. Both are owners of Rose Investment, and we bought this property in September 27th.
So you all are current owners?
We are the current owners, yes.
Okay.
We did meet last week with Mrs. Pomona, and the city did decide that we are recommending to release the current owner, Rose Investment LLC, from the lien fine that's on the property and keep it in place for the previous owner, Willetta Harmon.
Okay.
Mr. Riggio,
With clarifications that we would like to do a partial
Right.
release. The history of the case led the staff to feel that it wouldn't be proper or fair to reduce Ms. Harmon. So we would do a partial release only as to the property, which would leave the property free and clear for the new buyers,
Okay.
or free of our lien at least.
It's fine with me. Therefore, in the matter RTL 052199 for property at 836 Berkshire Road, I order a partial release of the lien with respect to the current owner, Rose Investment, and that would be a total release of the lien for that party,
As to that part.
for that
parcel.
party only.
Right, it would be a release as to
The amount of $16,213
Okay.
the
and
part,
44.
the parcel, so her,
Parcel.
she'll
right,
have the
'cause,
property.
Right, the encumbrance is as to the parcel and as to the person. So
Right.
we'll release it as to the parcel, so there's no more encumbrance on the parcel. And it'll remain,
And the lien,
as
and
to
that,
everything.
the $16,213.44 remains a lien against Willetta Harmon, who
And
was
any
the
other
previous
property
owner of
we
the
own.
parcel.
right. Is that clear? I'm sorry, was talking of the magistrate. I apologize, Mr. Magistrate.
That's fine. Ma'am, do you understand? You as the parcel, and you are currently released from the lien.
On the link.
The
So if,
previous owner remains subject to it. So if she owns property elsewhere, or has something that the city could initiate an action against, they can. But as far as the parcel and you, and Rose Investment as the current owner, there is no lien against that property.
no links. Okay, perfect. Yeah, because we are thinking to sell the property after we do some kind of things, and we want to have the clear title for the new owners. Okay?
Okay?
Okay, yeah, well,
That's right.
prepare it and file it in the public record, and I don't know what else you do. You send a copy to us?
I do.
Okay, and you'll be getting a copy of the release.
Okay, perfect. Thank you.
Okay, well, let's move to the cases. Irreparable, irreversible rental cases. Case number 1 is RTL 10-2362, Nalini and Aran Carmen Chandani. Are they present or on Zoom?
I do not have them on Zoom.
Okay. Are Nalini and Aran Karam Chandani? Is anyone present for them? No. Okay. There's no respondent present. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this district. The violation was first observed September 15, 2023, and they were notified the same day. The property was not actively advertising as of September 15, 2023. The daily posted rate was $90. The advertisement displayed 3 reviews. The check-in, check-out time were shown as 3 p.m. to 5 p.m. and 11 a.m. This is the second hearing at this address, the first being for RTL 03-2321 on March 28, 2023. These actions are irreparable and irreversible in nature, and due to this being the second occurrence, the city is asking for a one-time fine of $15,000.
Okay. Mr. Yates, you said that you noticed or first became aware of the advertisement on September 15th?
Yes.
And then you said it wasn't advertising on September 15th?
Yes. So I called the owner since this was a reoccurrence, and then after our phone conversation, they took it down again.
Okay. Do you know when the previous, probably in this book,
March 28th, 2023 was the first occurrence, and it was RTL 03-2321.
okay. And did they take it promptly down that time too?
It was at least 15 days on that one.
Okay. Now, sometimes was this on one of the major websites like VRBO?
Yes, they created a new ad and relisted. It was not the same ad that was reused, so it wasn't just reactivated. They went through the process, created a second ad, even to the fact of actually altering the front door through CGI. But luckily, I was able to. That's not. See, if you'll see that front door, their front door actually has glass in it, and so they modified that so that it would be harder for me to find. So they were actively attempting to obscure it.
Okay. Mr. Yates, when you search for these things, is there something common, like can you pull them up by address or something?
No, not at all.
You have to physically look through the information and see if it's a Daytona property?
So it'll say Daytona Beach, and then I'll have photos. Sometimes it'll have a general area, and from there I have to actually match the interior photos to other photos. So the photos in this case on the right are going to be, from the left are going to be from Realtor.com, and then on the right is going to be your Airbnb photos that match up with it. So as you can see, you go through photo by photo, you look at this, and yeah.
Oh, so they are trying to avoid
Yes.
detection.
Absolutely.
Okay, I have no problem with that. By the way, were there any reviews on this?
Three.
Three. So I would assume that the new ad has generated at least three rentals
Yes.
since the March.
Yep. Two and they brought it. Looks like they brought it in September because they have 2 in September and then 1 in August.
Okay, well, I think that's the first time that we've seen one where somebody has actually gone that route.
Yeah.
So therefore, in case number 1, RTL 10-23-6.
Magistrate, I don't know if you want me to present
that would
the,
probably be good.
irreversible one,
Although the respondent isn't here,
just so that the record.
you have it in, we will have it in the record of this proceeding. And to those individuals who are out there, I believe all of you are here on similar violations. Mr. Jackson will probably be asking if you want to hear this again, because it's a common argument that he makes in each one of these cases. And so please listen in if you're, and You can hear it again when your matter's called, or he will probably ask you if you wish to waive him repeating it. So, Mr. Jackson?
Yes, thank you, Mr. Riggio. As Mr. Riggio said, the magistrate has indicated, I will be presenting to you, Mr. Magistrate, the city's position regarding why these violations are irreparable and irreversible in nature, and the basis on why we're asking for you to make that finding. And our grounds are this: that the nature of the violations create a beneficial gain to the property owner, advertising the conduct that is prohibited by the code. The effects of holding our property as vacation rental is indeed irreversible. The property is advertised worldwide, marketing a destination that draws people from all over the world for principal events such as the Daytona 500 races, Bike Week, Spring Break to our world's most famous beach, and Biketoberfest and such other events. The properties are all marketed as a draw to nearby destinations such as Disney World and Space Coast. Once the properties are advertised, they are never unadvertised. The reality of the web is that you can't push it back into the tube. And so when they're put out there, when they're advertised, they can be forwarded, retweeted, even copied and pasted on other sites. And even after they're taken down, someone who has been there before may be making contact to return again. The information has long-range effects. It lures patrons under contract to participate in unlawful stays in our city with the risk of poor health, safety, and welfare due to unregulated or self-regulated vacation accommodations that the patrons enter at their own risk. One single day of advertising on one of those sites can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron, and they're definitely to the detriment of the licensed hotels, motels, and the lawful vacation rentals that have gone through proper zoning regulation, proper inspections, proper licensing, proper insurance, and proper taxation that's required by law. The transient nature of the rentals limit the means of the enforcement typical for the inspector to have to identify many of these through the advertisements. By the time code enforcement arrives to the properties, the transient patrons typically are gone from the property, or they claim some misleading relationships that are often contradicted by their advertised visitor comments. The monetary effect of these unlawful rentals is tax avoidance, inadequate insurance coverage, and unfair business competition against the lawful accommodations businesses and the lawful vacation rentals. The community effect is that transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from the traditional and reliable residential norms. There has been a demand, and it continues, from the business community to our commission, which has led to a request for a strong deterrent to those that are raking in profits, avoiding taxes, avoiding zoning requirements, and avoiding the regulatory controls. We have all seen rentals going for amounts as much as several $1,000s a week and realize substantial fines are the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city includes the advertisement of these rentals as part of the violation, and we request that the finding that those violations are irreparable and irreversible in nature be made by this magistrate. And because of the gravity of the violation is how we determine the fines. The gravity of these violations are based upon their impact, and there's cities that have these fines going to as much as $80,000 or $90,000. The Miami Beach had a case where the court said that's too much, but the statute allows for a maximum of $15,000 for such a violation when it's irreparable and irreversible. And that has been historically the city's position, that these violations should warrant such a fine. We realize that the magistrate over the, now having a couple of years of reviewing these, several years now, that there's been a pattern of the magistrate to give some relief to people who respond quickly in certain circumstances. In this case, the respondent acted previously, just a few months ago, acknowledged that they understood that it was a violation, and then once again initiated with clear signs of efforts to avoid detection. And with that being said, the gravity of violation, the effort of the respondent to comply, and its history warrants a request for a $15,000 fine. And so that's the city's request in this case. I have nothing further.
All right. In that regard, I would also note that the order, the standard order that it was issued back in March states that if they come back before the special magistrate again on the same violation, that I have the ability to consider a fine of up to $15,000. In this case, they're not only back, but they actively were apparently trying to disguise the fact that they were advertising by making changes so that it was difficult for the inspector to try and find it. Fortunately, the inspector found it. And so, do you have anything further?
No, sir, I don't have anything further. Thank you.
Mr. Yates, anything further?
No, sir.
Therefore, in case number 1, RTL 10-2362, respondents being Nalani and Aaron Karamchandani, I find the respondent for property at 582 Revillo Boulevard. I find the respondents to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that this is the second time that these same respondents for this same property have been found to be in violation of these two provisions of the Land Development Code, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 582 Revillo Boulevard. And hereby order and to have subsequently come into compliance on September 15th, 2023, and hereby order that respondent shall pay a fine in the amount of $15,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. All right. I would also note at this time, just so that it came before me, I think it was last month, or was it, that two of the matters involving these short-term rentals have gone up on appeal to circuit court, and both of them were just found favorably for the city. So the Carmen Chandians should be aware of that. Fines are imposable, and the courts are upholding them. Case number 2. This one's been here a number of times. RTL 10-2363, Stoza, Inc., cite for failure to correct violations of Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.a.2 at 932 Pelican Bay Drive. Is there anyone on Zoom for Stoza, Inc.? Is there anyone in the audience here on behalf of Stoza, Inc.? There is no respondent. Mr. Yates.
The case before you is a zoning violation. This case was a complaint. The property is zoned PDG. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed September 27th, 2023, and they were first notified September 28th, 2023. The property stopped actively advertising as of October 18th, 2023. The daily posted rate was $462. It displayed 3 reviews. The check-in, check-out time were shown as 4 p.m. and 11 a.m. This is the 4th time this owner has been in violation of the zoning ordinance, the previous cases being RTL 03-2321 on March 28, 2023, RTL 06-2342 on July 25, 2023, and RTL 09-2361 on September 26, 2023. This action is irreparable and irreversible in nature, and due to the actions of the property owner, and this being a multiple reoccurrence, the city is requesting a one-time fine of $15,000.
Okay. Mr. Yates, before Mr. Jackson does his irreparable and irreversible presentation and anything else that he wants to add, question for you. Have you been in communication at all with the homeowners association?
Yes, the homeowners association, yes, who have complained quite heavily, and I've also been in contact with the owner.
Is there a reason why the owner has finally stopped?
Well, he said it's not because of anything we did. He's just decided to stop.
Okay, so as of October 18th,
He pulled the ad down.
he pulled the ad down. Okay. All right, Mr. Jackson?
Mr. Magistrate, I'll start there with the questions you've asked. Whether it's because of us or not, I made it clear before, and it was my intent, and still is, if it should appear again. I think with the number of violations that have occurred, that it would strongly warrant probably an injunction, and would probably, obviously, depending on the will and desire of my client, the city, we very well would be probably seeking an injunction. So that may be part of the motive as well. And hopefully, if he has stopped and he will continue to not be proceeding in the manner that he has, then we're probably on hold with that. But where we are today is that we are seeking a fine. This is presented regarding him and on his behalf now 4 times, but I'll do it again just for the record. As previously requested, that the magistrate make a finding of irreparable and irreversible in nature, which is the requirement under the statute. And as I've said before, these are beneficial gains to a property owner whose advertising conduct that's prohibited by a code. And the effects are that he's holding out this property as vacation rental or guest rentals, and that's a violation of the code, and it's irreversible. It's something you can't undo. It's advertised as an opportunity to come to a great place, the city of Daytona Beach, for Daytona, the 500 races, for Bike Week, for to enjoy our spring break in the world's most famous beach, and for other great activities that we have here. It advertises for destinations such as Disney and Space Coast. And the information has a long-range effect because it lures patrons under contract to participate in unlawful stays in our city. And it lures them at a risk of poor health, poor safety, and welfare due to it being unregulated or self-regulated by the vacation accommodation. And so this person enters at their own risk. And as I've said before, just one day of advertising can book a property for a whole year. These are transient in nature, and the transient nature of these rentals limit our inspectors to sometimes have to rely solely on advertising. In this case, we've had numerous complaints and other information verifying people coming and going. By the time code enforcement arrives to properties, the transient patrons typically are gone, and the property, if they happen to be there, they're claiming that they have some relationship to try and be undetected as vacation rentals. The community effect is that the transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods. They diverge from the traditional and reliable residential norms. There's a monetary effect then. These unlawful rentals have inadequate insurance for their commercial use, unlawful business competition against the lawful accommodations business, and the lawful vacation rentals. We've seen rentals, and even specifically this one, just from what's been posted, that go for amounts of several $1,000s a week. They advertise $2,400, and we realize that substantial fines are the only deterrent tool available. And by the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. And so therefore the city requests a finding that these violations are irreparable and irreversible in nature. They've been repeated. Now this is our fourth time. The gravity is that it's showing a heavy impact and many complaints from a neighborhood where it's just not allowed. And it is repeat violation. So with that being said, the efforts of the respondent appeared, I think, at the first proceeding, has chosen not to appear and have allowed these fines to accumulate and has made no effort. Now he's making some apparent promises of possibly not doing any more, but has not shown any real effort of compliance on a consistent basis. So with that being said, I believe that $15,000 fine is warranted. We asked for a $15,000 fine to be imposed, and that's all I have.
Okay. All right. Therefore, in case number 2, RTL 102363, I find the respondent Stoza Inc. To have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. That this will be the 4th time that I have found this respondent to be in violation of those sections, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided before by Section 162.091D, Florida statutes, for the property at 932 Pelican Bay Drive, and to have subsequently come into compliance on October 18th, 2023. And hereby order, respondent shall pay a fine in the amount of $15,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Case number 3. RTL 102365, Keith Christopher Kong and Patrick Vibert Kong, cited for failure to correct violations of the Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.a.2, at 400 Oak Ridge Boulevard, number 0260. There's not on Zoom. Is someone here on behalf of the respondents?
State your name, please.
Keith Kong.
All right.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Mr. Yates, can you provide the particulars of this matter?
Yeah. The case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed on September 19th, 2023, and they were notified the same day. The property was not actively advertising as of September 20th, 2023. The daily posted rate was $106. The advertisement displayed 3 reviews. The check-in, check-out time were shown as 4 p.m. and 10 a.m. Due to the actions of the property owner, and this being irreparable and irreversible in nature, the city is requesting a one-time fine of $1,000.
All right. Mr. Jackson.
Mr. Kong, I know you've been in the audience and heard me make a presentation for irreparable and irreversible. I'll ask if that's something you need me to present again to the magistrate. You will have our opportunity, whether I present it now or if he adopts it, to speak to that presentation if you so elect. But is that something you need me to present again, or is it something you would waive?
No, I'll waive that. I heard it.
Okay. Therefore, the respondent in this matter hereby waives Mr. Jackson repeating his presentation regarding irreparable and irreversible, and that presentation, as previously provided in the previous cases, case number 2, in particular RTL 102363 Stoza Inc., is hereby incorporated into the record. However, Mr. Kong, if you take objection to any of that, we're just placing his argument in the record. That's all.
Okay.
All right. Mr. Yates, do you have anything further?
No, sir.
Okay. Mr. Kong, do you have anything?
I do. I just, I don't really feel that it's fair. I think it's kind of I guess in a hearing like this, unjust, probably be a better word. But, I mean, I know that I spoke to Mr. Yates, and we talked about how, like, ignorance isn't an excuse, right? Ignorance of the law. But to my knowledge, we did everything that we needed to. We talked to the president of the HOA, who told us that he had checked with the city and we had clearance. Like, it's not just me here today. You'll hear from my neighbors in another case. I mean, Mr. Jackson mentioned tax avoidance. We've been paying taxes. We worked with a management company that did the groundwork and said that we were clear. Like, literally everything that we did, we thought we were doing right. I mean, if it was like a plea kind of thing, it'd be no contest, right? Mr. Jackson, you mentioned that one day of advertising can book an entire year. That I don't think that ever happens. Like, we saw a lot of these listings where the prices were $400 a night and stuff like that, and compared to, you know, the big pools and stuff, like, this was a single mom and 2 kids trying to make some money and thought we were doing everything right. You know, unlike the cases earlier, we complied immediately. And I know, Mr. Magistrate, that you personally have fought in the past to also reduce the fines from $15,000 minimums to $1,000, but even $1,000 is a lot of money. Half of Americans make $30,000 a year. So I just feel like we tried, we did what we thought we had to. We paid taxes. I mean, I don't know that anything's ever changed. The only thing I would do is ask for some kind of reduction at $750 or something, because to our knowledge, we thought we were doing everything right.
Mr. Kong, which homeowners association is this?
The Summer Winds.
Summer Winds. Okay. And is there another, Mr. Yates, is there another matter that's involving them as well?
Yes. The next matter will be from a
Okay.
different condo in the same location.
And Mr. Kong, can you elaborate on you said that you had tried to ask around. Now, obviously, it always comes down to the city is probably the best person to ask if you're asking about whether or not it violates the city code.
And both of those are under the same management company. So that also would be why they probably, if the management companies think it's okay to violate for one, they would assume the same thing for the other.
Okay. So this is a management company that is running or involved with these homes?
Yeah. Now, are you MJ Ventures? Is that your company?
No.
Okay.
Now, but having said that, we've talked to other management companies in the past that have also said this is good to go. So, like I swear, everything we thought, we had no clue, and when we got this, we complied immediately.
Well, I understand.
Absolutely.
I understand, but it's kind of a, we've been doing this now for 4 or 5 years. By now, you would think that every realtor and management company in Daytona would know.
You would think, and I actually watched, Mr. Yates told me I could go online and watch some of these, and I can't remember if it was you or Mr. Jackson in a past hearing that mentioned, I think the quote was, you would think the message would be out by now, but it's not. We don't know. We didn't know.
If I can just say this, Mr. Magistrate, the difficulty here is that we need someone to be going back to these management companies and fighting them. I mean, it's okay to fight us, but it's bothersome that a management company can tell you wrong, leave you with a consequence, and then you feel stuck. I'm not instructing you, but I'm just saying that you feel stuck. And we'd like for the management companies to not be telling you that. We'd like for the realtors, as you've probably heard people say as well. When I bought it, the realtor told me it'll be okay. We'd like for them not to tell you that. But our principal obligation, or our principal belief is that we would tell you right if you were to ask the city. And you're starting a new business.
Well, but that's why, I mean, paying tax to the city, we figured maybe the city would say, like, hey, by the way, I mean, technically, isn't the city like our co-conspirator in this if they're accepting taxes off of that? I mean, it's...
To be clear, you're paying your taxes to the state. You're not paying any taxes to the city.
I
The
don't think
taxes
that's
go to
correct.
the property appraiser.
Yeah.
And they're assessed by the city. There is a portion that comes back to the city, but
But it's not related specifically
it's not
to your
related
business.
in any way to the business. So you're not being taxed. There would be, if you, I assume, and I'm perhaps venturing a little bit beyond, but the property appraiser places a valuation on property based on its use, and I assume this property is being taxed based on being a single-family home with a homestead exemption.
I should clarify what he's speaking of is that he went to the state and he signed up to pay this taxes through the state for his short-term rental.
Okay.
And he did do that.
They will accept anything.
Yes,
I
they
believe.
absolutely will. But I was like, this is what he's talking about. I just wanted to clarify for him.
Yeah,
And we've run into the same problem with the county because they have their bed tax or whatever it is, and they will also accept, and
actually, I believe some of these short-term rental venues will actually draw that as part of their package, right? And under the taxing. But again, that taxation is state and county, and it's not really the city.
Well,
I mean, not to debate the tax.
Right.
There's a whole lot of other issues.
but just to speak to your statement, because you mentioned tax avoidance being a thing, and you mentioned I think you said the business community, and like to me, it just kind of sounds like hotels got together and were like, hey, let's lobby the city and keep our profits and hurt the little guy, and that's kind of, I mean, what it is. When you mention irreparable and irreversible, then it's almost like if it's irreparable, what's the fine for it? It's just, I feel unfair, like I said.
there is a bit more to this. For instance, and it doesn't necessarily relate to this one, but a fair number of the short-term rental properties tend to have other code issues associated with them, such as like during the events where people are drinking all night and they're in a subdivision and the people next door have to get up in the morning and go to work. Okay, and so they create all of these issues. If this goes on in a hotel, one, it may be permissible. The hotel may have thick enough walls that the people don't care. Or two, if it gets out of hand, the hotel sends up somebody from their staff to quiet the people down. There is absolutely no management of these units. If they get out of hand, if they decide to shoot off fireworks at 2 in the morning, they can do it until the police arrive. These are things that should not be happening. Most licensed rentals have somebody who is ultimately accountable. The city has a long-term rental license program. Also has a short-term rental license program for those small areas in the city where this is permissible. But there's always somebody who's accountable. On these, there's no accountability. And I have had situations where people have been bitten by animals, dogs, et cetera, brought in by people who come in out of town, and they decide to, and all kinds of horror stories. And that is, this particular property may not have been a problem in that regard, but there are enough of them that the rules have to be enforced. Now, I'm willing to reduce the fine in this one to $750. That I can do.
Thank you.
But as far as whether or not it is a short-term rental, it is a short-term rental. It's on one of the short-term rental websites. It's held out as one, and that is about that's where I come from on that. And that is just the city's rule. And unfortunately, there is a lot of misinformation that's floating around, and I don't want to, I think some of it is basically calculated misinformation, because a lot of the individuals should very well know that they shouldn't be advising people that these things are allowed. But it does work to their economic benefit to lead folks astray. And so, with that said, but they are not here before it's the homeowner who is ultimately accountable in a code enforcement proceeding.
Yes.
I have nothing further.
Anything further?
No.
Okay. Therefore, in case number 3, RTL 10-2365, I find the respondents Keith Christopher Kong and Patrick Vibert Kong to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible, because the improper benefit obtained by the owner and the damages surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes, for the property at 400 Oak Ridge Boulevard, number 0260, and was subsequently come into compliance on September 20, 2023, and hereby order the respondent shall pay a fine in the amount of $750 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank
you. If you can get the word out to the management companies and anyone that you speak to about that, it is not permissible for short-term rentals in most areas of the city.
No, I know I can go.
And they can find out if it is permissible by checking with the city. And
There's nothing like that here today, is there, that I could have with the zones?
The city's website has it listed on the GIS maps, and it'll highlight every single address that allows it.
Oh, thank you.
Thank you.
Good job.
Okay. Case number 4, RTL 10-2366, Jonathan Greco, cited for failure to correct violations of the Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.a.2 at 400 Oak Ridge Boulevard, number 0080.
Good morning, Mr. Greco. Can you hear me? We can't hear you.
There we go. I apologize for that.
Thank you. Could you state your name, please?
Jonathan Greco?
And raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay.
The case before you.
Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed September 19th, 2023, and they were notified the same day. The property was not actively advertising as of September 20th, 2023. The daily posted rate was $90, and the advertisement displayed 59 reviews. The check-in check-out time were shown as 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson.
Yes. I believe it's Mr. Greco.
Yes, sir.
My name's Anthony Jackson. I'm the attorney for the city. I typically the person on Zoom have been able to hear what's been going on throughout. I don't know if you have been or not, but I'll present to the magistrate a position of the city regarding determination of that the violations are irreparable or irreversible in nature as pursuant to Chapter 162 of the Florida statute. I can make that presentation again if you've heard it and you elect to waive that. That's something you can do, and I won't make it again. And but you would have the opportunity to speak to it just as the gentleman did in the prior proceeding. With that being said, is it something you would like me to present again, or is it something you would waive me presenting again and accept it being made a part of the record?
No, sir, Mr. Jackson. There's no reason for you to repeat your presentation.
Okay.
Okay, thank you, sir.
And let the record reflect that the respondent has waived Mr. Jackson making his presentation regarding irreparable and irreversible. And that previous presentation is incorporated, it was made previously in case number 1 and number 2 is incorporated into this matter. All right. Mr. Greco?
Yes, sir.
This is your opportunity to state your position.
Thank you, Special Magistrate. I do want to touch on a couple things regarding Mr. Jackson's presentation and its applicability to our short-term rental there. He had mentioned a couple items of interest regarding the irreparable and irreversible damage to the city. He had identified having inadequate insurance coverage being an issue. That was not the case here. We did almost double the insurance for this property to ensure that our insurance coverage for our guests and for the property itself covered short-term rentals. He had identified density, that having short-term rentals in particular in these properties can lend itself to having higher density of guests than what is allowed. That is not the case here. The Summer Winds Condominium Association has communicated to all its members, including us, that the zoning limitation is 6 people per unit, and we strive for that day in and day out. We had very in-depth rules that we provided to our guests to ensure that any guests that we had staying in our property were in compliance with that zoning by only limiting 6 guests to our unit at any point in time. And we stuck to that. We maintained monitoring equipment on the property, on the outside of the property, to identify the number of people that were going in and out of the unit at any point in time, including animals. We also included inside the unit noise and smoke monitoring equipment to ensure that the noise level that was within the unit during what we posted as quiet hours, anything after 10 p.m. was down to an acceptable level. And if not, then we would follow up with a guest immediately. And we did have somebody on site who would go to the property to make sure that the rules that we provided to our guests, including quiet hours, were being maintained. We were in full compliance with the state and local taxing authority to try to be in compliance with our responsibilities for recovering sales and tourism tax and remitting that to the local taxing authorities. We tried to, we were very in tune with wanting to be good neighbors, so much to the point where I have taken it upon myself to take my own personal time to be a member of the board of Summer Winds and to make sure that all, if any, questions or concerns that were raised by neighbors were addressed, and that we were as good of a neighbor as any other unit who had a long-term renter in the units. Most of those units in that complex are rented out. A minority of them are actually used by the owners to stay in. Okay, I've stayed in the unit more than some of my other neighbors have stayed in their units because they've always rented them out. And they have, those units are almost, you know, I can say that are not in any better shape than my unit, and are not as responsive and responsible for what happens in their unit as I have been. With that said, I understand that I was not in compliance with the zoning. I did not know that when I bought the unit. I was told by my realtor that it was in short-term rental, that the prior owner used it for short-term rentals, that the condominium association allowed for short-term rentals because it was in zoning for short-term rentals. Otherwise, I would not have bought the unit. Upon receiving the taped-on notification by the city inspector, I immediately took it down for short-term rental, and I posted it for sale because I do not intend to continue owning it and doing short-term rentals on it, because now I am aware of zoning. During Mr. Jackson's presentation, he talked about how fining is the only way to get people into compliance. And I assure you, Your Honor, that is most certainly not the case here. A simple phone call from Mr. Yates in discussion, providing me with knowledge that this was not in zoning compliance, we would have repaired the situation immediately, like we did when he taped a posted, you know, the letter on the door. We addressed it immediately, just like we've addressed everything else with this property to make sure that we are a good neighbor and in compliance with everything. I do apologize to the court for not checking the zoning personally myself. I wish I would have, because I would have saved myself a lot of grief at this point. But with that said, I would request a reduction to the fine. I would request that, sir, that you do recognize how I've taken responsibility for being a good neighbor and doing everything I thought that we needed to be in compliance. And you know, I don't know if Mr. Yates shared with you, sir, our review score by our customers. This was not some Roach Motel that we were flipping, trying to get every little penny out of and being a harm to the city of Daytona or the guests. That most certainly not the case. We were a super host on Airbnb, extremely high ratings across the board for providing an excellent experience to our guests and being that good neighbor. And so, you know, I do not absolve my responsibility to this matter, because ultimately, like you've said before to others today, I am personally responsible for it not being in zoning, and I understand that. I understand that now, and I will be in compliance with that going forward. But I would ask for leniency here and recognition of the fact that we did not cause harm to the city during much of Mr. Jackson's presentation is not applicable here. So with that, I'll be quiet. Thank you.
Thank you.
Mr. Ritchie, I'd like to respond just for the benefit of Mr. Greco and for the record. First of all, Chapter 162, as it relates to the issue of irreparable or irreversible in nature, is what the statute says. It's not irreparable harm, but it's the nature of these violations. So they're not specific to each case, everything that's said, but the general nature of these violations create the things that were stated. Mr. Greco indicates that he's on the board, a member of the board. That's concerning to me. He purchased this property in May 20th of 2022. He indicates when he purchased, he realized he was wrong. But here we are now, more than a year later.
Mr. Jackson,
I'm to speak, Mr.
Okay, go ahead.
Greco, so allow me to speak.
Allow Mr. Jackson to finish. You'll have an opportunity to respond, Mr. Greco.
Here we are more than a year later, and he's saying he's just finding out about the advertising. I'm not challenging whether that's true or not. I'm just saying it's suspect when it's that far down the road. And the biggest concern here is that we have a condo unit, which even on his own phraseology kind of calls it a motel. It's not a motel, it's not a hotel. It's condo units that are not authorized to do the activity that they're doing. If they're doing it great and they're doing it nice and everyone loves it, that's all fine, but it's not legal. It's not permitted by the code. And so because it's not permitted by the code, it is a violation. I spoke of the fact he mentions how much they are regulating it, and that's wonderful. But if it's not being regulated because of the fact that it's not lawful, it's being self-regulated. And some people may do that very well, and others may do that horribly. And so there's no uniformity in regarding the regulation of these rentals. Short-term rentals, otherwise in our city that are in an approved zone would have governmental regulations. So with that said, none of those things I'm saying to say don't treat it like we treated the last one. You were willing, based upon the circumstances and what was expressed, to reduce it to the $750. I'm not opposed to that. I just wanted to speak again to some specific things that were pointed out for the benefit of Mr. Greco as well as for the benefit of the record.
Okay. Mr. Greco, did you want to?
I didn't. Let me clarify. I did not mean to refer to my condo as a motel. We never treated it as such, nor did we look at it as such. I think that's in reference to the phrase roach motel, which was more of a slang that I shouldn't have presented here. Just trying to identify the fact that this was quite the opposite of anything that you might find there in those motels on Ridgewood. Regardless, also wanted to clarify that I must not have been clear in that when I bought the unit in 2022, I did not know that I was going to be out of zoning compliance with doing short-term rentals. We were told by the board by the board president at that time that we were allowed to do short-term rentals, not vice versa. So I just want to be clear. We first became aware that we were not in zoning compliance when this letter was taped to the door in September. We immediately, not a day later, not a week later, not a month later, immediately upon receiving notification that this letter was on the door, we took it down because we wanted to be in compliance and identify what was going on before we did anything further. Okay, that has not changed. So, Mr. Jackson, I appreciate your willingness to have, to not be combative regarding my request to have a reduced penalty. But I just wanted to clarify that it must not have been clear. So, thank you for that.
Okay.
And if I could just say one thing, if you are a member of the board, sir, and if I can say this, Ms. Magistrate, if you're able to communicate at large to the members that it's not lawful, that would be very beneficial to us all.
Yes, Mr. Jackson, I recognize that, and I have been in conversations with the president of the board regarding this matter, and I will continue to do so at our annual board meetings coming up in November, and I anticipate that this is going to be a topic of discussion. As you can imagine, it's a small community of 26 units, and so when 2 of the units had these messages posted on doors, it has been quite the topic. So it will be discussed in November, and the community will, I'm sure with my neighbors, will ensure that units are in compliance with this.
Thank you, sir.
Okay. All right. Well, I just want to weigh in a little bit on this. Mr. Greco, it's your building sounds like it would be run the right way if this use was permissible there. So, I mean, and unfortunately, and I'm not sure if you're aware of this, but it is right now an issue with state law that creates some issues here because the city can't alter its short-term rental ordinance because of a statute that would basically create all kinds of dire problems if it was done. And so you all are caught in the middle, but unfortunately, there is income being realized through a use that is currently not permissible in the city and can't be made permissible until state law is ultimately changed. And that is the biggest problem. And I understand your frustration. I've been hearing these cases now for, I think, about 4 years. Yeah. And there are many other properties similar to yours that have fallen in the same position. There are also, unfortunately, properties that don't really care. And in many cases, the one-night rental oftentimes may offset fines that are imposed or the number of rentals that have occurred over a month or what have you, because Daytona is a destination area, especially with the beach and the races and all of those and the events that occur here. So I'm willing to reduce, as I did in the other matter, the fine to $750 as opposed to what would normally be assessed under these circumstances, basically because of the situation in your building and your efforts to help perhaps prevent other people from falling into the same trap as you are in terms of having short-term rentals that ultimately are being deemed to be not permissible. And that's about all I can do at this point. So, therefore, in case number 4, RTL 102366, I find the respondent, Jonathan Greco, to have been in noncompliance of Article 4, Section 4.1a and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 400 Oak Ridge Boulevard, number 0080, and will subsequently come into compliance on September 20, 2023, and hereby orders respondent shall pay a fine in the amount of $750 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Right. Our next case is number 5, RTL 102367, Mario and Molly Lamoureux, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1a, Article 5, Section 5.2.8.2 at 120 Bellevue Avenue.
Good morning. Can you hear us?
Yes, I can.
Could you state your name, please?
I'm Molly Lamoureux.
And Mario Lamoureux.
And raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned MFR 40. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed September 19th, 2023, and they were notified the same day. The property was not actively advertising as of October 11th, 2023. The daily posted rate was $115. The advertisement displayed 9 reviews. The check-in check-out time were shown as 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay.
Sorry.
Mr. Jackson?
Mr. and Mrs. Lamoureux, my name is Anthony Jackson. I'm the attorney for the city of Daytona Beach. I have previously presented to the magistrate the city's position regarding irreparable and irreversible in nature. I don't know if you were able to hear that, or were you
Yes,
listening?
we heard all of them.
Yep.
Is that something you need me to repeat or want me to repeat, or is it something you would waive?
We will waive.
Okay. As stated before, I will be asking the magistrate to make it part of the record for this case, and you'll have any opportunity you desire to speak to what has been said regarding my position.
Okay.
Thank you.
All right, then let the record reflect that the respondents have waived the incorporation of Mr. Jackson, or have waived any objection to incorporating Mr. Jackson's arguments regarding these types of, this matter having irreparable or irreversible issues. All right. Mr. and Mrs. Lamoureux, this is your opportunity to state anything you would like me to take into account.
Thank you, sir. Well, we bought this property just in June. We live far away out of state. We were searching for a legal investment property, like to use on Airbnb and to visit occasionally with our family. Unfortunately, we thought we were doing everything correctly. We met with a real estate agent in Florida. We found a property manager that had experience with short-term rentals, and both of those people assured us that we were following all the rules appropriately. We found this listing, this property online. It said that the sellers had actually been using it as an Airbnb. It was fully furnished. It had been going well for them, and they were selling it, and we thought it would be the perfect opportunity for us. So we were just taking over something that we thought was already allowed. So we had purchased it. Like I said, we'd not even had it for 3 months when we got the cease and desist letter in the mail. So we contacted our property manager right away and said, please take this down. And unfortunately, we had no idea that this wasn't allowed. I think your case number 3, I was surprised to see he had a lot of similarities to us. We had also filed all of the licenses through the state and the county that we thought we had to do to have this as a legal listing, and we actually have the same property manager as him, which I did not know. So it's an honest mistake. We never would have bought this house had we known that it wasn't allowed. And unfortunately, you know, we didn't even really own it long enough to make any very good income off of it. So for us, we just now have a vacant house out of state that we wish we didn't own. But along the way, you know, we paid for insurance and everything as well as if it was a rental property. So our full intention was just to follow the rules, and we're very sorry that we just, I guess, ignorantly didn't know. But
Yeah, we had our real estate agent, the seller's agent, the property management company, all told us, no, this is fine for short-term rentals. So basically we got the licensing that we thought was, I guess, correct. You're leaning on, I guess, what you consider professionals to get you the correct information, give you lawful information. And I guess we're trusting in those people to make sure they're doing their due diligence. And I guess for us, we should have done it ourselves, but we don't have the experience in it. Is that's why we paid
people to do it.
professionals to do that. And I would say that unfortunately we were wrong.
And just to add some clarification, this property manager, all the properties they were hosting were illegal. So unfortunately.
I did call him after we got our letter, and I said, how could this be? And I think he just told me he didn't know either. He said he has his own personal properties listed as well, and he said it was devastating for him too because this was his whole business. But so you just take people at their word. Unfortunately, we were wrong.
If I can say, Mr. Magistrate, and
Mr. Jackson.
Speaking as to the limit rule,
Yes.
I'm probably saying it wrong, but I'm doing the best I can.
Close.
It's great.
But, unfortunately for the city under these circumstances, we really have no regulatory power over this management company. We have to look to people who have been misled or misrepresented, if that's what you believe, and trust y'all to handle that aspect of the misfortune. It's hard for us to make substantial adjustments on or even acknowledge. We understand people will be in a situation where they didn't know and they tried to rely on others. That's normal. And I commend you for trying to do what you do in business. Ultimately, you're still the ones who own the property, and you're the ones who, and it's a hard one to recognize with especially with real estate rental, whether it's short-term or long-term, that it's still a business, and getting the business information, what's authorized, what's not authorized, you want to go to the jurisdiction that grants that, which would be the city. So it's unfortunate that you didn't get that take that move to check with the city, and if you were telling us the city told you wrong, would be looking into that here.
Understand. Honestly, when we applied for those licenses, we thought that's what we were doing. We thought we were getting permission and being, upfront. I think you just don't know which part oversees what. We don't, that's not something we deal with very often. So.
I hear. I'll leave it to staff in terms of ultimate recommendation, but I just wanted to address those things with you.
Thank you.
I will say one thing, and that is that from the standpoint of to follow up on what Mr. Jackson said, I've heard years of people relying on people's word and to their detriment. There is a courthouse, and when people feel that they've been wronged, there are remedies that are available to them to recoup monies that may have been expended, unfortunately, based on reliance on other people's statements. But as Mr. Jackson stated, the city only has control over the property owners, and although it tries its best to get the word out to all of these people, whether they choose to listen or whether they find it to their own economic benefit to mislead people is something that is, as I see it, is beyond the city's control. That is a matter that is personal between you and the people you rely upon to provide you with the information you need to make the purchase of property or enter into some type of business arrangement. And that's just unfortunate that you have managed to run into people, as many have so far over the years. I mean, almost every one of these matters involves somebody who, generally it comes back to a realtor or a property manager who says something can be done, and it can't.
Right.
And I'm in these proceedings, there is no ability to go after these people unless they are actually the owners of the property. So you are the ones who are on the front line, so to speak, with respect to these matters.
I understand.
Mr. Yates.
And just to clarify, I did confirm once again, they did apply and get both of the taxes from the state.
Okay. All right. under the circumstances of this, I'm willing to reduce the amount of the fine to $750, as we've done in the other matters where it's clear that people have been horribly misled. But ultimately, some fine has to be levied because, unfortunately, I'm in a position where I have to rely upon what is said, and I know that there are people out there who will say the same thing who are actually not misled, but are simply trying to avoid a fine. And that's a difficult situation to be in, to try to ascertain that, the facts, those types of facts. I have to look at it based upon what I believe the credibility of the people who are saying it, their circumstances, and what they relate. And so I'm willing to reduce the fine to $750. Hopefully that makes things a little less burdensome for you.
Can I just say this for the record, Mr. Riggio?
Yes.
It's the city's position that the $1,000 fine is appropriate, but we're not objecting in any way to your reduction to $750. I think we've kind of fallen into that for this hearing, the circumstances that have arisen through these hearings today. But it's our hope that we don't redefine our minimums. And it is very difficult to tell who's good and who's bad, who's truthful and who's not truthful. I do see a nice couple with a cute baby in the back, and that helps a lot. But it's just really, because it's so hard to know, that's the whole reason we drive for the consistency. But I have no objection to, based upon what we've done through this, the hearing today, to your reduction.
All right. Do you have anything further?
No. Thank you.
Okay, therefore, in case number 5, RTL 10-2367, I find the respondents Mario and Molly Lemerow to have been in noncompliance of Article 4, Section 4.1A and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 120 Bellevue Avenue, and to have subsequently come into compliance on October 11th, 2023, and hereby order respondent shall pay a fine in the amount of $750 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you. Case number 6, RTL 10-2369, Robert and Nancy Beverly Hackman, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.A, Article 5, Section 5.2.8.2 at 715 South Beach, number 112D.
Could you state your name, please? You can pull that micro. There you go.
Nancy Hackman.
And raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Ma'am, I didn't catch your name.
Nancy Hackman.
Nancy Hackman. Thank you. Mr. Yates.
All right, the case before you is a zoning violation. This case was field generated. The property is zoned MFR 40. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed September 13th, 2023, and they were notified the same day. The property is still actively advertising as of today. The daily posted rate was $87. The ad displayed one review. The check-in, check-out time were shown as 4 p.m. and 10 a.m. Due to the actions of the property owner, and this being irreparable and irreversible in nature, the city is asking for a one-time fine of $15,000.
Okay. Mr. Jackson, do you have something?
Ms. Hackman, I don't know if you've been here throughout. I've presented previously to the magistrate the city's position, the city's position on making a finding that these violations, the nature of these violations, are irreparable and irreversible. What the statute says, the finding would be that it's irreparable or irreversible in nature. And so I present to the magistrate while the city feels that he should make such a finding. I don't know if you were here to hear any of those presentations.
Yes.
If not,
I was here.
okay. Well, with that being said, if it's something you'd like me to repeat, I'll be happy to repeat it for the magistrate. If you want to waive
Not
me
at this
repeating
time.
it.
Not at this time. We're good.
So you want me to waive? You're waiving me repeating that?
Right. Not
Okay.
at this time.
Okay, let the record reflect that Mr. Jackson's presentation on the city's position on irreparable and irreversible, as he originally presented in case number 1 RTL 102362, Nalini and Aaron Carmenchani, is hereby incorporated into this proceeding, and that the respondent has waived him having to read this into the record again.
Ms. Magistrate, if I can just speak to the fine, our basis for fines are, if the matter is the gravity of the matter, the effort to comply with the code, and the history of the violator. In this situation, the inspector reports that the property remains continually advertised. And with that being the case, we believe that a $15,000 fine would be appropriately an appropriate imposition for which is the maximum fine because of the continued violation.
So noted. Okay. Ms. Hackman?
Yes.
It's your opportunity to speak to this.
Okay. Well, it isn't advertised right now. It's already been rented out for the next till October.
It's on the website as of this morning. You can go. This ad that you're seeing right here is currently available.
It is on the website.
Yes. So you're agreeing it is on the website?
Yes.
Okay.
And it's on there for 6 months rental.
If you go to the next slide, sorry, keep going. And you'll see right there, those are the dates that I put into book. Those dates were available at the time, September 15th to September 22nd, so which is much shorter than 6 months.
Starting date,
September 15th, end date, September 22nd.
okay.
And then it shows the
Yeah,
total
if you
would be
complete,
$995.
if you complete all of that, it'll tell you it's a 6 months.
Unfortunately, that's not how that works, and it would also need to be 6 months and a day. So if it's only 6 months, then it still is a short-term rental.
Ms. Hackman, you seem to be walking into an area that, if I'm correct, 6 months in a day is a long-term rental, if it's in fact licensed with the city, because the city does have.
Yes,
Let
it
me
is.
explain this. There's short-term rentals are night by night. VRBO, Airbnb are short-term rental websites. Okay. You can legitimately rent out your property for 6 months and a day, provided that you possess a rental license from the city.
Right.
You can't get a short-term rental license at this location from the city, but you can get a long-term rental license.
Is that, I believe that's what I have right here.
Yes, sir. She has a long-term rental license.
Correct,
Okay.
but it's being offered short-term.
Right.
But it's appearing on a short-term rental site. Why? Why do you need to have that there?
I was under the impression that I could do it for the 6 months, but I cannot.
No, it has to be 6 months and a day. And as I said, if you look at the ad, it shows that you can book for just a week.
You are advertising. The city's Mr. Jackson, maybe you can speak to this.
Yes, I can.
Relative to the posting or holding out as an advertisement.
And that's just what it
Okay,
is.
I'm misunderstanding it. I understand what you're saying now through this whole process. I thought that you could put it up for 6 months, but you cannot.
Right, even if you're doing it like every, someone rented it every day as under these terms for a 6-month period, your advertisement term is
Okay.
still just like
So I have to
you're
take,
being at a hotel.
I'm misunderstood. I can take that off because it is already rented to someone the beginning of the year for 8 months.
And you have some kind of contract,
Well,
that's just
ma'am, you have to obtain a license from the city to
She
do
went
that.
and obtained she did go get a long-term rental license, is what I'm being told.
Yes, she
Yes.
has I believe it's been inspected and
Correct.
final.
I
But she
have to-
definitely
yeah,
applied and.
And that was
Well,
as of which date, do we know?
I'm sorry?
I said, which date would that have occurred? I mean, what's the date of approval
Of the license,
of the long-term rental license? Yes.
I have paperwork right here.
On approximate date this month?
And then I do also
Yeah,
have
paperwork
this,
is
when we
something else.
did purchase it as a retirement home. And this was in the,
What I would like to do on this one,
That's your condos rule. It has nothing to do with the city.
yeah, that's something that might, that's in the.
That's
Yeah.
just a rule
Now,
you guys
I know
agreed
that
to.
Now,
yeah.
after all of this that happened today, I do understand that now. But when you look in your condo bylaws, you see different things than what is really legal.
what does the condo,
It says it has to be longer than 30 days in the condo bylaws.
well,
But that, yeah.
that's sort of irrelevant.
Yeah.
Okay. But when-
My job is to try to enforce city rules, not condo rules.
Well, I'm just
And-
letting you know, this is the knowledge that I had to go by.
What I would like to do is to continue this matter and allow Mr. Yates or somebody who does the long-term to work it out. Because if you already have a long-term tenant there, but you have a advertisement on a short-term rental site, you are essentially, you have contradictions going on here. You have a tenant with a lease that's 6 months and a day, I assume.
No, she does not. She's saying she does not have a 6-month and a day lease, correct?
I have, after the holidays, yes, I do, right
So-
now.
so right now, do you have a
we're
6-month?
staying there.
I would like to continue this matter so that you all can work this out, because I don't want to assess a $15,000 fine or levy a $15,000 fine against somebody who is appears trying to work with this in the system, but I hate to say this, is confused.
Mr.
the-
Riggio, I
the-
can confirm that she has an active long-term license as of May.
Right.
Okay.
There are people, and we have run into this before, who have tried to use long-term licenses as a disguise for short-term rentals. And so, as Mr. Yates has noted, the first thing that has to be done is that advertisement on the short-term rental platform has to disappear,
Okay.
okay? And then you obtain a renter. I don't-
Mr. Magistrate, if I just can point out, if I'm understanding her right, and she's said it several times, there's two things. One is that needs to disappear as soon as possible. And the second is that if I heard her right, she has some anticipated short-term rentals or anticipated rentals.
No, that would be
An-
me being there
Okay, so,
An anticipated long-term rental, correct?
after the holidays is already in motion?
6 months and a day at least.
Well, it's 8 months.
8 months, that's fine.
So no more, no rentals from this point forward, and,
Short term, unless it is
Yeah, right.
me, my family members, that they're not renting, but they're, you know.
But I've run
You wanna
into
give
this
them that.
before. There are people who come forward who want to be on who say they want to be on a rental website to accommodate family members. I just don't, I can't buy that. You're a phone call away. You know, Aunt Gertrude wants to come down for a week. That's, you know, you can certainly have Aunt Gertrude, but when you start advertising on a platform that is holding out for advertising, and it could also include people, any people who are not family members, and I can't distinguish who's a family member and who's not. I'm trying to resolve this in such a way that what Mr. Yates has stated is the normal way that this matter would proceed. You are the first person that I'm aware of who's come forward licensed on a long-term rental basis, and I just don't understand why you just don't take the ad down immediately.
I will.
And Mr. Yates, if you could make yourself available, because you seem to be able to get these things down.
Had she called
ASAP.
even one time, this would have been resolved. Unfortunately, she's not communicated at all, and that's why we're in the boat room right now.
I'll tell you, Mr. Magistrate, Ms. Yates had given us a flex number in terms of, depending on when she resolved this, as far as our recommendation. The recommendation is only 15,000 because as of today, it's not resolved. Well, I understand your desire and what you've expressed, Mr. Riggio, and of course, the staff will be responsive to that. I won't make any promises. I don't think the staff will make any promises as to what our recommendation would be in the future as we return. But we would like to return. I'm sure you're continuing it. And I think that the nature of our recommendation will be built on the actions taken by this respondent and the way whatever she understands or seeks to understand about what she needs to be able to do next. So with that being said, puts a little bit more work on Mr. Yates a little bit, but an immediate takedown will help her, I'm sure, in moving from 15,000 to maybe something less than that. At least from our recommendation.
That's
of course, ultimately.
no,
that
I
decision
agree wholeheartedly with that, because I'm trying to accommodate you because of the fact that you already have a long-term license. Okay? I don't want to hear Mr. Yates come back and say that he has now gotten wind of short-term rentals going on at that property after we're trying to work through this because of your situation.
The city would also be amendable to dropping it to the next lower fine that we do, to sort of say that, yes, you should have communicated with us, you should have taken it down, which would be $5,000, if that would help settle the matter today.
You're saying now or after you?
Now.
Auto.
Yeah, $5,000 as of now, and it's assuming that it's going to go into compliance today when she takes it down. Because obviously the minimum would still be, even with compliance.
No, auto fine is not appropriate in these. I would not recommend us doing any kind of an auto fine because this is the first time before you. We don't know of her subsequent actions, and we need to make our fine recommendation commensurate with the actions that she takes.
Okay.
In my opinion.
I understand Mr. Yates's position. I also understand your position because it sort of mirrors where I'm coming from. The problem here, ma'am, and unfortunately there's only you and one other person and whoever watching, is that under normal circumstances, people get these and first thing they do is they call the code inspector and say, what can I do to remedy this? Because nobody wants to have a code violation. And all of this would not have occurred had you simply picked up the phone and called Mr. Yates. And then all of this could have been worked out some outside of this proceeding, and you might not be responsible for any fine, okay? But you have managed to work yourself into a position where
Well, I believe I do. My phone, I do have where I called you. In the beginning.
In any sense, if I can say this, I understand now better. The only reason we're making a recommendation that was being made is because we hadn't mentioned at the front end, but of course, we're not, we don't anticipate having November or December, right?
Correct.
Right, anticipate having November meetings or December meeting for rentals unless we schedule special meetings because of where they fall in the month as relate to the holidays. So our next meeting would not be until January.
okay.
And so that may be what the thought was, but I think it's still the same question in terms of the effort and intent of the respondent. She needs to respond immediately, and our report, if we come back in January, says she didn't, and that we want to hire a fine. I don't want us to lock ourselves in on a fine
No,
without
the
knowing
amount of the
action.
fine is still up in the air.
Yes.
And well, I would like to hear in January a nice report from Mr. Yates that everybody cooperated, everybody worked together, we got this resolved, and that there is a tenant occupying, not a long-term tenant, and that there are no short-term rental problems, and there's definitely no short-term advertising.
And
Okay, we
just
can resolve
communication
that
with the
today.
inspector would help a lot. So just keeping, I know you said you have, but just keep in communication, make sure he knows when you take your next step.
Yes.
Okay.
And this is all to your benefit, okay? And so we're trying to work through this, and hopefully you can get everything resolved.
Okay. Thank you
All right.
very much.
But you will be continued until the January, do we know what the
I think
Jan?
it's the 24th.
Oh, I have it right here,
23rd, my bad, 123.
123.
So I should be here 123?
That will depend, well, yes, you should be, because at that point, Mr. Yates will make a report back to me on what has transpired,
Continued order.
and then I can make a determination based on how things went.
Okay.
And that would go to,
You have a license, though, right?
Yeah.
And has your property been inspected and gone through all of that? So, okay. You're a bit different than a lot of these other properties where they have no licenses, they've never been inspected,
Well,
and
I
they're
plan on,
way
I
outside
plan on
of
living here.
Hmm?
I said, we bought that as a retirement home, that we plan on living here.
Well, I understand that, but
Lives in Michigan.
I've met you for the first time today, as most respondents, and you'd be surprised the things that respondents say, and I can't. I just have to believe everybody is trying to be as truthful as they can, and sometimes I find out that's not true. So
yeah, we have an unusual situation here in this large gap. We don't normally have such a gap between our proceedings. Ma'am, we have the Michigan address. It's the only address. Would that be the best address for sending
Okay.
your notice for the next proceeding? You may want to make note in case for some reason you don't get it, that we're saying the next hearing would be January 23rd. But we will send a notice to the best address that we have.
Okay.
Okay. And I don't want to hear anything from Mr. Yates about, oh, the property was rented out for a week and a day because, well, we needed some extra money, or that.
won't be hearing that.
That type of rental is not allowed in the city.
Okay.
And that will help that, all of that will be taken into consideration on the 23rd of January in terms of how we resolve this matter.
Okay.
And I'm trying to help you.
Thank you.
So please try to help the city
Mr.
in terms
Yates,
of getting this resolved. All right, so therefore, in case number 6, RTL 102369, Robert and Nancy Beverly Hackman, property at 715 South Beach, number 112D, is hereby continued until January 23rd, 2024. That's it.
Thank you. Thanks, Mr. Yates.
Thank you.
Right, case number 7, RTL 10-2370, Orain and Aisha McFarland, cited for failure to correct violations of Land Development Code Article 4, Section 4.1A, Article 5, Section 5.2.A.2 at 353 Seaview.
Step up to the microphone and state your name, please.
Hi, my name is Raheel Taylor. I'm here in regard to case number.
Go slow. Your name is?
Raheel Taylor.
Wrong case.
Yeah,
We're case number 8.
you're not here for case number 7.
No, I'm not.
Okay.
Okay, they're actually here, so we'll go ahead and
Okay,
take their
okay.
case. We didn't
Okay.
realize
Yeah,
they
just
were-
have a seat right there. They're appearing via Zoom. Okay. On Zoom, can you hear me?
Yes,
we
ma'am.
can hear you.
Yeah.
Could you state your names, please?
Orain McFarland.
And Aisha McFarland.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you.
Okay, Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed September 6, 2023. They were notified the same day. The property was not actively advertising as of September 7, 2023. The daily posted rate was $100. The check-in, check-out time were shown as 4 p.m. and 10 a.m. I met a guest on site claiming to be from Airbnb on September 6, 2023. Due to the nature of these actions being irreparable and irreversible and the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson, do you have anything to provide?
Mr. and Mrs. McFarland, Anthony Jackson, attorney for the city of Daytona Beach. I've presented to the magistrate a position regarding irreparable or irreversible nature to ask that that be the finding made by the magistrate. I don't know if you've been on, if you've heard that presentation. If you have, my question for you would be, is that something you need me to repeat, or is that something you waive me repeating, but recognizing that you still have an opportunity to speak to whatever was raised in that in my statement?
Yes, sir, we waive.
We waive.
Thank you.
Okay, then let the record reflect that the respondents have waived Mr. Jackson's presentation of the city's position on irreparable and irreversible as previously set forth in case number 1 RTL 10-2362, styled Nalani and Iran Carmen Chani. Okay. Mr. and Mrs. McFarland, it's your turn to state your position in this matter.
No, we accept Mr. Yates's findings. As you see on the advertisement, we do have a property management company. We're based in Georgia. And if you go down, I don't know if he got a screenshot of that. We have a property management company that handles it. So we come and spend times there during any time the kids are out of school. But we had a property management company handling it, and we were paying taxes. So we pay taxes to them based on the conversations we've already had previously that you guys explained. It looks like it's Florida sales and use tax, which is state tax and not the city tax, which we are now aware of. And we also had insurance through our property management company as well. But we understand based off the previous conversations that were held with the previous cases that information doesn't matter. So we were just trying to see if there's any way that we could receive a warning. We took it down basically same day that we were notified that it was an issue, and we've never had a violation before. So.
Okay. Mr. Jackson, do you have anything to add?
Well, I think you know what I would have said in the past. I think the way we've been considering today, it's kind of
falling in line consistently with misinformation to people who are out of area. And I'm okay with if you elect to reduce it to the 750. I would ask the McFarlands if they ran and got the baby after the other case, why acknowledge the cute kid?
Yeah, she
waiting.
was actually due today. So
Wow.
It was a due date.
Congratulations.
thank you so much. But yes, we did let our property management company know, which I feel as though is the reverse standard, that this is not the area that allows short-term rentals. So from the conversations that we had with them, I believe that they did take down, or they remove, or they're telling people that that area is not permitted for short-term rentals. So I don't think you will have any issues out of that property management company anymore, and we're fully aware of it as well. So
Yeah, I don't know if you will have any other communication with them, but if they contact the code division, they'll show them how to go onto the GIS and check the zoning. I mean, it's not something that's very difficult for anyone, and it would be ideal for them to just check if they're going to tell people the information about zoning.
yeah, that would have been beneficial to us. So I apologize.
Yeah. That's everything from me.
Okay. Mr. Yates, anything?
Nothing more.
Okay. Under the circumstances, I'm willing to reduce the fine to $750, but that is, as we have on the other matters today. And so that's what my determination is going to be. There's going to be a fine of $750.
Thank you.
Thank you.
Okay, so case number 7, RTL 10-2370. I find the respondents Orain and Aisha McFarland to have been in noncompliance of Article 4, Section 4.1A, and Article 5, Section 5.2.A.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 353 Seaview to subsequently come into compliance on September 7th, 2018, and hereby order that respondent shall pay a fine in the amount of $750 and not violate that section of the Land Development Code again, and that for any future repeat violation, a respondent may be placed on subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Thank you.
Thank you.
Okay. Sir, you wanted to appear here today?
Yes. Okay, so it's me again, Raheel Taylor. I'm coming in regard to case number RTL 09-2356. I was here at the last hearing that there were. I don't know if it was the last one, but I think it was on the 26th.
Yeah, if I can say, Mr. Riggio, this is not on the agenda.
I know it's not. I'm just trying to find out why you're here and maybe.
I'm
You
here.
said it's RTL 09
23. Yeah, 2356.
56, and that was that on a previous agenda?
Yes.
He just signed those.
Which month?
September 26th.
September 22 of this year?
Yes.
Okay.
He has it.
Do you have the minutes from the last meeting?
It's on page 6, if you wanted to see the minutes.
Oh, okay. Okay. Do you mind if I read through the minutes of this first so I have an
Yes,
idea?
please.
I don't recall what occurred on September.
You should have in the front.
Yeah.
Okay.
Mr. Jackson's right there.
Where's Mr. Yates?
I think that Sergeant Blowers went to see where Kevin went.
Oh, it wasn't going anywhere.
Should I proceed?
I'd like I think Mr. Yates was handled this matter, so he's most familiar with the particulars. All I saw was on that day, it was like 15 minutes or 10 minutes or whatever, and
I mean, I don't mind hearing him out. I'm not, I don't know what he's requesting. I would be opposed to taking any kind of action. So,
well, I at least put him on another agenda.
I understand. And just for the sake of Mr. Taylor, my opposition is because you're here, but because of public records requirements that you're not on the agenda. That's why I would oppose us taking any action.
We can't take any action today, but we can at least hear
Right.
what it is you have to say.
I understand. I mean, I appreciate whatever help I could get because I can't get help about this matter anywhere. This is actually what I was told from the help or the people at the desk and stuff. So it's really, you really don't know what to do. So a lot of times people are trying to do the right thing, but there are really not much resources for them to follow. But I came in regard to the amount of the fine that I received. Firstly, I would like to say that the information that I felt like they bring forth was incorrect. Yeah, so I currently have basically, my family lives in the property. Even the information that they say that we're on these websites making all this money, that is not the case. I think they showed an Airbnb site or whatever he was showing as his evidence, which I have no knowledge of those information or whatever pictures there was that the guy was showing. So I don't know what that was because I actually have my family living in the property now, me and my wife and my brother. I see the other couple there with their kid. I'm actually expecting a kid as well, but it's terrible for me right now. Since I moved to Daytona about 1.5 years ago, things has been real rough. I actually have my mortgage statements here. I'm currently almost $12,000 behind on mortgage. So for them to say that I'm making all this money and I have an Airbnb, which is not the case, and then turn around and find me $4,000. So I really don't want to fight because I don't know how to fight against the city because I don't know all the rules and stuff. So I'm just trying to, at least at minimum, I would hope they could give me at least a $500 fine because that's the only money I have in my bank account. But I understand that's a stretch. But I would like to receive a reduced fine. Everything on this case to me is wrong, but I don't want to fight. I don't have the funds. I don't have the means to fight the city. So I'm just saying being reasonable with me, especially due to the point that he has no evidence against me against this stuff.
Mr. Taylor, I'm going to kind of cut you off at this point. This is something you need to take up with Mr. Yates, okay? And then if you have arguments, then you bring them back at another hearing. And
I guess one thing, as Mr. Taylor's asking for some direction.
well, I
I'll let you
understand he
finish.
was.
I mean,
I'm
I was
looking
gonna
at
say
the
something
minutes.
else.
He was
Yeah.
present at the hearing.
Right.
And the original amount of the fine that was requested was, I think it was $5,000. It was reduced to $4,000. And I understand
Ridiculous.
I understand what you're saying. If you don't have 4,000, difference from 5,000 to 4,000 don't make much difference. But that is not something that I can take up today because that has to actually take place at a hearing. And you need to communicate with Mr. Yates. And I don't know if there is any, what resources or whatever available, and then it comes back before me. I can't do anything today.
So,
And Mr. Magistrate, I wasn't going to speak to what he said other than to just say that which is something I've said before. I don't know if I said it to him. An understanding that what happens when these fines are imposed is that they are recorded in the public record and they attach to the property as an encumbrance on the property if they're not paid.
okay.
And when they attach, they're there, and they just stay there until they're paid.
Right.
So if there's a concern about an immediate must pay, there's no, in that regard, unless you're trying to sell it right now or trying to get a loan against it, there's no immediate must pay related to code or liens that attach to property.
Okay, so my question is, why is other people's being fined $750 and
All those other
$1,000?
conversations that I don't know if we can, I mean, that's up to the magistrate. I
And
don't know if we
No,
I
I
feel
don't
like
think we
I should get that type of break if anyone is. I mean, I just came from paying $8,000 in taxes, and less than a month later, I was hit with this fine. Like, this is not monopoly money. I don't even make $5,000
What you need
a
to
month.
do is, what you need, sir, to do is request a rehearing,
And how do I go about doing this?
and I'll be happy to put it back and hear it again. But it has to be done, it has to be on an agenda and properly advertised and things of that nature. I can't make any accommodation for you today.
And this is what I was told by the council that's here. So I was going from courthouse to courthouse. I mean, it's really nothing. If you can point me in that direction to get another hearing or something, or I just at least want to reduce, I really can't afford that. I don't make that type of money.
My determinations are made based upon the facts that were brought before me, okay? And I try to treat people equally, and I am not especially concerned about their financial condition, because someone who's a millionaire could come in here wearing rags, and someone who is a pauper could come in dressed to the nines. And so I don't know, I don't know your financial status, and to some extent, I don't care, because to some extent, equal has to be across the board. And I'd be happy, you can discuss it with Mr. Yates, and if you feel that you've been, you need to be reheard, then we can put you back on and rehear the matter. There may be no change whatsoever, and you may still be in the same situation as you are now. But I can't change things until it's been actually brought before me on an actual hearing.
Okay. And he's
And
gonna
as
tell me how to
Mr.
do the
Jackson
hearing?
said, nobody is coming after you for the money right now. It's become a lien on your property.
Wouldn't that incur interest as well? As I think they said it's already too much for me. And then they said it's going to be a filing fee, and it's going to be.
That's what you do. Here's your appeal. That's your next step if you don't agree with the decision, is to appeal it with the appellate court.
Well, that is another opportunity, but since this was heard in September.
Yeah, I think it's kind of out of time for a lot of stuff.
Yeah, so I mean, it's irreversible.
What's the date? What's today's date?
Today's date? Today is the 24th.
Well, you got 30 days. From the order, so I don't know when the order was imposed, but you have the law for that regard. I mean, from a general assistance, there's people you can talk to. It won't necessarily have anything to do with our code in terms of other programs we have. Someone may be able to direct you to those. As far as the code, personally, and I'll just say this right now, I would expect the staff's position would be, and it would be the appropriate position, would probably oppose a rehearing because we had a hearing. But that's going to be ultimately up to, hold on.
Okay.
That's ultimately up to the magistrate, but I'm just telling you what our position generally would be on a request for a rehearing. So, but there are possible other ways that you can get some assistance from the city, and if someone had directed you to those, maybe you already went there, I don't know.
Okay, if I hear correctly, from what you're saying, this is based on financial circumstances, and that is not a consideration that I take into account in these hearings.
Well, I'm not saying financial circumstances only, but due to the fact that the situation that they're saying or accusing me of is not true. I didn't see him come forth with any evidence.
Sir, you were here at the hearing.
Yes, sir.
And so, strictly speaking, your remedy if you feel that you were not treated properly at the hearing, is to appeal it to circuit court. Okay? There are opportunities for rehearing, but they're very unusual circumstances. And the fact that you can't pay the fine doesn't necessarily, I don't think it falls into any of those circumstances. On the other hand, the fine simply becomes a lien, and you're not paying anything, and the lien can attach to the property for years.
But I was told it would incur interest as well, and
It collects interest, but the interest isn't all that much.
I mean, you guys think 5,000 isn't a lot, and I think that's detrimental to, I work a whole month and I don't make $5,000.
We don't think that, we don't think that. That's just the guidelines that they use in imposing these. So to get in touch with Mr. Yates, and he can guide you for any other assistance. I mean, we can't rehear the case today. It's not on our agenda.
And the issue with that is I was received notice on the 1st, and I was in court by the 26th. I wasn't even given enough time to seek legal counsel or to talk to anyone about this situation.
That would be your responsibility to have requested any of that either before the hearing or during the hearing, and which you did not, correct?
I mean, I did try to get in contact with you.
Here we go. We had the hearing. We have a record of the hearing, and anything that you want to do in terms of challenging the hearing, you have the rights to, the ability to speak to counsel, you have the right to speak to legal counsel and follow whatever recommendations they give you. No one's trying to in any way impede your rights, but what we're telling you is that this is where we are in the process. And so if there's help now that you need, there's ways that may be out there, but where we are in the process is where we are in the process.
All right. Well, thank you for at least hearing me out.
Thank you.
All right. Unfortunately. Yeah, well, so should have reminded you at the beginning, but we don't typically have continuances that we were going to, the decision had been already by staff that we would not be having meeting in November and December.
Right.
And I guess, hopefully they had already communicated that to you, but in any sense.
Right.
Yeah, they didn't communicate it to me. but that's
Did
good.
not?
I didn't know.
Oh, I'm sorry.
Right.
So I don't have anything further.
Is there anything further?
No, sir.
Okay. It being 11:18, I call this session to be adjourned.
All right, have a wonderful